Morning, Your Honor.
All right, good morning. Good morning. Going to go ahead and call this particular case, cause number DC 19-17313, Niels Ulrich Oldenburg et al. Versus Margot O. Burrell. I show it to be set this morning for a motion for partial summary judgment filed by the plaintiff. Is that correct?
Yes, Your Honor.
Okay, all right. Let's go ahead at this time and have some announcements on the record. I have Mrs. Roos on the Zoom hearing with us, so she's taking the record for us. Let me just start by saying I'm Judge Monica Purdy. I don't know if I know everybody on this particular Zoom. New judge of the 95th District Court. So I just want to take a moment to introduce myself, but let's go ahead and unmute some of our Zoom screens and make announcements on the record, and then I will hear from the plaintiff with respect to their motion for summary judgment, and then I'll hear a response.
Thank you, Your Honor. Jason Dennis on behalf of the plaintiffs, Ulrich Oldenburg, who is the uncle, and Eric Oldenburg, who is the son of Steen Oldenburg, and Jan Oldenburg, who is a minor, and Ulrich is bringing on his behalf.
Thank you.
Your Honor, Mark Caldwell here on behalf of the plaintiffs.
Sarah Torson on behalf of the plaintiffs as well.
I think that means it's my turn, Your Honor. Good morning, Alan Lowenson, and I represent all of the defendants.
All right, thank you. So who is going to be arguing on behalf of the plaintiff?
I will, Your Honor.
Okay,
Jason.
I'll hear from you, Mr. Dennis.
Thank you. And if I have to admit, I haven't done this before. If I have a short PowerPoint, because it was our first hearing in front of you, and I want to give a few of the background facts to sort of orient you to the case.
Okay, that would be great. Let me, Mrs. Rouse, who's the court reporter, I believe she has to do something to share her screen in order to allow you to show your PowerPoint. So Mrs. Rouse, if you could go ahead and do your technical magic in
Yes,
Zoom
ma'am.
so that he can share his screen.
Yes, ma'am, I did.
Okay, thank you. So Mr. Dennis, you ought to be able to do that now.
All right. Okay, that works, everybody should be able to see it.
Yes.
Let me just start out at the beginning. So Jack Burrell, to orient you, the plaintiffs, as I said, are the uncle and the two children from his deceased brother, Steen Oldenburg. The defendants are Ulrich's mother, Margot Oldenburg, and his sister, Kelly Oldenburg, Steen's sister as well. And so all this stems from Jack Burrell, who was their stepfather and the deceased husband of Margot Burrell. When Jack Burrell died, he left amongst his estate various oil and gas interests to have a life estate to provide an income for defendant Margot Burrell. And it was generating, as it notes here, maybe $100,000, $150,000 per year in royalties the year before they sold it. But that's not particularly important to what we're here for. And then Kelly, Ulrich, and Steen Oldenburg all had a 1/3 remainder interest in all those oil and gas interests. And I put in per stirpes because the will specifically said per stirpes. So if Kelly died, then her children would get her share and share amongst her two boys. If Ulrich had died, his children would have shared. They're both still alive, but Steen ultimately did die, and I think there's no dispute he left two heirs. His son Eric, who's also a plaintiff and is 18, and then his son Jan Oldenburg, who's a minor, and Ulrich Oldenburg, his uncle, is bringing it as his next friend. And where this happens in 2018, they go ahead and solicit to sell the entire interest. So to sell the life estate plus the 3 remainder interests, and ultimately they get an offer, and I won't go, the details of all this transaction probably will come up in later proceedings, but for the point of this proceeding, which is rather simple, they get an offer and they agree via purchase and sale agreement that all of them would sell their interests for $15 million to Blackstone Minerals. So after the sale, basically net of, there was an adjustment to the $15 million sales price, and there were some commissions related to the brokers. But ultimately, $12.864 million are the proceeds of this transaction for these 3 remainder interests and the life estate. And then after that sale, $2.3 million was transmitted to Kelly Oldenburg, who's pictured there on my left. In the middle, $2.3 million was given to Ulrich Oldenburg, one of the plaintiffs, and no money was given to Steen Oldenburg, the third child, who had the 3rd remainder interest. I won't, for the purposes of this hearing, we don't have to go into all of the details, but basically what happened was the 2 transfers were made to Kelly and Ulrich, and Steen was in Costa Rica. Ulrich's in Costa Rica as well. He had trouble getting back to the U.S. He had a Denmark passport. He also, I think it's undisputed, had a terrible substance abuse problem. Ultimately, he arrives in the U.S. to receive his share of the proceeds at that point and dies in a hotel in Dallas, unfortunately. And these are his pictures of his boys, Jan and Eric. He doesn't receive his distribution at that time. Later on, so at this point, Ulrich has gotten his part of his portion of the proceeds in $2.3 million, and the rest of the money, $10.564 million, is held by Margot, the mother, and Kelly, the sister. So the issue before us, I'm getting ahead of myself. The issue before us is rather straightforward. Basically, Jan and Eric, after they buried their father and mourned, had their attorney in Costa Rica say, "Hey, what happened to our father Steen's share of the proceeds?" And Dan Britton, on behalf of Margot and Kelly, who was the attorney for the whole group in this transaction with Blackstone, wrote back and said, "Steen, Kelly, and Ulrich expressly relinquished any share of these proceeds. Therefore, Steen's estate has no ownership or rights in these proceeds." this letter ultimately led to this lawsuit, and the issue before you today, while there's a lot of briefing on it, from our part is only about 1.5 pages because it's, in our view, very straightforward and absolutely black letter law. The deed that they are relying on for this gotcha that Steen lost his interest and his children and the state don't have any share of the proceeds is that the remainder interests were transferred to Margot. So the purchase and sale agreement was signed where they said, we will all sell this for $15 million to Blackstone. And then in the week between there and the closing, working with these Glass, Phillips, and Murray attorneys, they did some tax planning, and ultimately they transferred the remainder interest via deed to Margot individually. And then Margot transferred it to her trust, and then her trust transferred it to Blackstone. So this all happened between the signing the purchase and sale agreement and the closing. What they are claiming in saying that Steen is not entitled to anything, even though 1/3 of the remainder interest in this $15 million sale was his, is what Mr. Britton points out, that he relinquished his interest via deed. And what we will say is the deed they are relying on cannot be a relinquishment or a gift because the recital recites good and valuable consideration. And we'll show you, I think we cited in the briefing, you cannot, via the parole evidence rule bars, any contradiction in trying to argue later on that a recital of good and valuable consideration was actually a gift. There are a bunch of cases, and I don't think they even effectively dispute that in their briefing. But the importance at that point is, if you have recited good and valuable consideration, then you can't later claim it's a gift, and you've got to prove consideration. And in this case, there is no dispute that Steen didn't receive any valuable consideration. We have no further to look than, let me make one point before I get to the consideration, because basically that's our only 2 points. Is one, if you have a deed that recites good and valuable consideration, it cannot be a gift. There has to be good and valuable consideration. And point 2, that Steen did not receive any consideration. There is, Your Honor may have seen some substantial briefing from the defendants about the rescission remedy. Now, we certainly are going to have a discussion, later on about remedies and how we ultimately solve this problem. And rescission, we think, is one way in which it may be done. But we're not arguing that today. We're not trying to reach a final judgment. The issues that we are trying to resolve, we only had one sentence in the brief, and that's not the relief we asked for related to rescission. We are just trying to establish this was not a gift, and Steen did not receive any consideration. So with that said, they do make a point about is relinquishment the same as a gift, which relinquishment is the term that Mr. Britton used in his letter telling Jan and Eric that Steen had given up all of his right to the $15 million. But we asked him in his deposition, and I said, and sometimes you've used relinquish and sometimes gift. Are you using those terms interchangeably? And he answered, I am. No ambiguity there. This is what I just mentioned a few moments ago, and it's on very first page of our brief, on page 7. There's really one page of argument because it's a very straightforward point. The deed that they are relying on that transmits Steen's remainder interest to Margot Burrell, the defendant, says, now therefore, in consideration of the transactions contemplated in the PSA and the covenants contained in this deed, and other good and valuable consideration. So having recited consideration, this is one, and there are a number of other cases that say the same thing, where a deed contemplates consideration, it cannot be a gift as a matter of law. So the next half of the argument is, did Steen receive anything? And we have to go no further than Dan Britton, the attorney for the whole matter, and Margot Burrell in her own words. Here's Dan Britton. This is Exhibit 6, the Britton deposition, Exhibit 6. And we sent the pleadings. You'll notice we filed the summary judgment, and then we filed some supplemental exhibits before we set this hearing. but the exhibits are consecutively numbered. So Exhibit 6, which I believe is attached to the supplemental summary judgment evidence, has excerpts from Mr. Britton's deposition. Question: to your knowledge, did Steve Oldenburg receive anything in return for, as you described, relinquishing his remainder interest in the Blackstone Minerals? Answer: no. We asked the same thing from Margot Burrell. This is Exhibit 5 to the summary judgment evidence. Question: what did Steen get in return for transferring to you his remainder interests? Answer: he got the satisfaction that I would be taken care of from now on. Question: did Steen receive anything else for transferring to you his remainder interests other than your testimony that the satisfaction of giving you that interest? Answer: did Steen? No. So I was trying to unshare my screen.
All right, Mrs. Rouse, do you need to do anything to?
I think I got it.
Okay, there you go.
So that is in simplicity our argument. Now, there are a number of arguments made in response, and one of the reasons this hearing got moved and we added that supplemental evidence is surprisingly the defendants came back in their response and said, whoa, we're not arguing that it was a gift. But in fact, their attorney, when they told us, they told Jan and Eric Steen had nothing, says relinquishment. We asked him what that means. He says it means it's a gift. So we are talking about gift, and while they have not pled it, which is the reason why we're not challenging their affirmative defense, they didn't plead it as a defense. Instead, they just argued it substantively. So we brought the declaratory judgment to resolve this issue because this is really a principal issue in the dispute. This is their basis for saying, I gotcha, and we get to keep Steen's money because he gave it up in this deed. But while a very legal argument, and in your first week as the new district judge, I know consideration and parole evidence rule are not at the top of the list. But the law is clear. The parole evidence, once you say there's good and valuable consideration, parole evidence doesn't allow you to come back and try to prove it was a gift given for the satisfaction of his mother being taken care of. And they, in their own words, both from their attorney and from their own client, say that he did not receive any consideration. So we think there's no factual dispute, and it's certainly an issue in dispute. As their first two arguments are basically in response. There's no justiciable controversy. We're not really saying gift. Whether they're saying relinquishment, gift, they're relying on this deed as a justification for why Kelly and Margot get to keep his money. And I do want to, I won't spend much time on this, and if Mr. Lowenson emphasizes it, I'll come back to it in response. But one thing to focus in on, it's not that you cannot have a gift deed. You certainly can. And there can be valuable consideration, not as to existing creditors between two spouses. So, for example, you deed to your spouse or significant other half of the house. Love and affection can be recited as a basis for that gift deed. And also, there's case law that allows that to be from a parent to a child. No case law, and the two cases he cites are parent to child. No case law that it works from a child to a parent. And in fact, we cite in our response the Johnson v. Driver case, which says the opposite, that the interest in caring for an aging parent are not sufficient consideration. But we don't get to that point, and the reason why is their love and satisfaction in those two cases that Mr. Lowenson cites are cited as the consideration. So we're not trying to decide whether love and satisfaction was sufficient in this case because they cited good and valuable consideration. They have to prove good and valuable consideration. And while in a gift deed, love and affection of a spouse is sufficient consideration, except as to creditors, it's not in this case because it's not good and valuable consideration. So for these reasons, we would ask that the court grant our partial summary judgment as to one, there being unambiguously not a gift because the deed requires good and valuable consideration, and that can't be changed now because of the parole evidence rule. And two, because both Margot Burrell and the attorney for the transaction, Dan Britton, admit that Steen received nothing in exchange for this deal. Thank you.
All right, thank you. Counsel, your response?
Good morning, Your Honor.
Good morning.
As I indicated, I represent the defendants who oppose this motion. This is obviously our first time before you. I don't anticipate it's going to be our last based on other motions I expect to be filed. So I thought first I would give you a very brief overview of this case from the defendant's perspective. As you might suspect, we have a different perspective. Margot Burrell, who lives in Dallas, one of the defendants, is now 80 years old. Jack Burrell was married to Margot. He died. He left in his will a life estate and various mineral interests, meaning the right to royalties during her lifetime. His will provided that at her death, 3 of her adult children from a prior marriage, Ulrich living in Costa Rica, Steen living in Costa Rica, and Kelly living in Dallas, would, if they survived Margot, get a third remainder interest in the minerals. But if they didn't, then their children, if they outlived Margot, would get their share under the terms of the will. In 2016, Margot began to get offers to buy some of those mineral interests that she received from her husband, Jack. An oil and gas consultant was hired who fielded offers. He told Margot that the wells were quickly dwindling and there was not going to be much future interest in those wells, so she ought to hop on the bandwagon now and monetize those interests during her lifetime so she would have the money to care for herself during her lifetime. One thing you didn't hear in the PowerPoint from Mr. Dennis is that this oil and gas expert also concluded that by the time Margot was expected to die, based on her life expectancy, whoever of her kids or grandkids survived her, they would have remainder interest, but they would be worth nothing. So ultimately, Margot got a $15 million offer from a company called Blackstone. But Blackstone, I guess being careful, also required the 3 adult children to sign off on the deal since they were believed to have these contingent remainder interests. We believe the evidence at trial will show that Margot has been a generous and loving mother throughout their lifetime. So the 3 kids signed off on the deal to help their mother monetize and get this money now. And the 3 kids, as you heard, each signed a deed transferring to Margot whatever their interest was. She then transferred all her interest to a living trust that she set up. And the living trust then deeded those interests to Blackstone. And Blackstone paid who? Margot's trust, and only Margot's trust, $15 million. And I'll get to what the PSA said, the purchase and sale agreement said in a minute. After the deal closed, Margot then made a decision to give gifts to each of her 3 adult children of about $2.3 million each. She gave the gift to Ulrich. She gave the gift to Kelly. And she was going to give the gift to Steen, but tragically he died before she could do so. Now, for a variety of reasons that she's testified to in her deposition that are not germane to the motion before you today, Margot made the decision not to give the gift she was going to give to Steen to his 2 children in Costa Rica. It was her money and it was her decision to make. The central dispute in this case is that the plaintiffs, and specifically Ulrich, claims there was some oral agreement that required Margot to give a quarter of the net proceeds to all 3 kids. And this is despite the fact that the 3 kids signed off on the purchase and sale agreement that showed expressly no money going to them and only money going to Margot's trust. And despite the fact that Ulrich, after the sale, referred to the $2.3 million he received repeatedly in emails and texts as a gift from his mother. But let's go to the motion at hand. Now, as I read the motion, they were asking for 3 things. They were asking for a declaration this was not a gift. They were asking for a declaration there's been a failure of consideration. And they were asking for a declaration that Steen had a right to rescind, even though, interestingly, it wasn't asking you to rule there should be rescission. It sounds like from what Mr. Dennis says that he has abandoned the 3rd one and is not asking for that declaration. If that remains the case, I refer you to our briefing where we advanced 6 arguments why they wouldn't be entitled to that declaratory judgment action. There was no response. Now, for some reason, Mr. Dennis comes back in response and says, no, I am arguing then I'll address those, but otherwise I'm not going to waste the court's time. So let's talk about the first two.
And if Your Honor, I'll be happy to, just so that there's no dispute, we made a one-sentence point about the rescission. We are not arguing that we didn't ask for that relief, so you may safely presume that's not before the court.
Okay, thank
Thank
you.
you. Appreciate it, Mr. Dennis. All right, so let me address the first two. The first one is their request for a declaration that the conveyances in the deed were not a gift. We've advanced three arguments why that should not be. I think I heard Mr. Dennis briefly mention part of one, so let me go through them. The first is it's not appropriate because they have not met their burden on summary judgment to prove there is a justiciable controversy. As the court knows, and some general principles of law, the stated purpose of the Declaratory Judgment Act is to settle and afford relief from uncertainty and an insecurity with respect to rights, status, and other legal relations. That comes from the statute. The Declaratory Judgment Act is intended as a means of determining the parties' rights when a controversy has arisen, but here's key language, but before a wrong has been committed and is preventative in nature. This lawsuit, they allege all kinds of wrongs have been committed, which we dispute. The law also says that a declaratory judgment is appropriate only if a justiciable controversy exists and the controversy will be resolved by the declaration. The Texas Supreme Court has explained, quote, to constitute a justiciable controversy, there must exist a real and substantial controversy involving genuine conflict of intangible interest. And then the court says, a trial court has discretion to enter a declaratory judgment so long as it will serve a useful purpose or will terminate the controversy between the parties. Now, we've cited a number of cases where actually the reverse has happened of today. A motion for summary judgment was granted against the plaintiff because there was no proof of a justiciable controversy. The courts say a declaratory judgment does not vest a court with the power to pass upon hypothetical or contingent situations or that are not essential to the determination of an actual controversy. All the questions may in the future require adjudication. As I indicated, the crux of the controversy in this case is whether there was this oral agreement. We say there wasn't, they say there was. The cause of action, therefore, has fully matured. The action involves an appropriate present remedy at law, so you don't need a declaratory judgment. Additionally, they've not offered competent evidence that the defendants themselves have ever taken the position that these were gifts. They've cited Dan Britton's testimony, and I'll get to our motion to strike in a moment. But even if you don't strike his testimony, what Dan Britton, who was an attorney who previously represented Margot, says was or was not a gift is not a position taken by the defendants in this lawsuit, as proven by the plaintiff, for which you should enter a declaratory judgment. They reference the letter where Mr. Britton says you've relinquished an interest. Again, what Mr. Britton wrote is not what the defendant's position is in this lawsuit for which there would be a justiciable controversy. So they haven't met the first burden of showing there is a justiciable controversy. They say, well, you rely on a deed and the deed says there's consideration, and if there's consideration, there can't be a gift. But the problem is, you just heard when I get to the second argument, they've said the consideration that we say is in the deed is not valid and doesn't exist. If that were true, then it might be a gift. You can't decide that today because those are fact issues in dispute, which I will get to in a moment. The second reason, which was not addressed by Mr. Dennis, that's in our response, the declaration is not appropriate because it will not terminate a dispute. We cited law that says a declaration is not appropriate when a party is seeking in the same action a different enforceable remedy, and a judicial declaration would add nothing to what would be implicit or expressed in a final judgment. Now, the Dallas Court of Appeals in the Sanchez v. AmeriCredit case, which we've cited, stated, the matters on which Sanchez sought a declaratory judgment were nothing more than affirmative defenses to claims in which the parties had already joined issue, and had no greater ramification than the defenses that were presented when the counterclaim was filed. The declaratory judgment is not available to settle disputes already pending. Here, the reason they want this declaration is because it's a mere step in their chain of arguments to get to some relief. They want to argue it was not a gift, it required consideration. They want to argue there was no consideration, And then they want to argue the deed fails for a failure of consideration. But even if they win on all those arguments, of which the supposed declaratory judgment is just the first step in those arguments, we've cited law that mere lack of consideration does not prevent a deed from conveying title. Thus, standing alone, this sub-issue of whether or not there is a gift does not resolve or terminate the larger dispute about whether the deed fails and whether they get their remedies. And the last thing we point out is the fact that there is no justiciable controversy. This request should also be denied because they are seeking to use this request to obtain attorney's fees against my client, which would be inappropriate. So now let me turn to the remaining issue. This request, even though it wasn't clearly stated today by Mr. Dennis, but it is in their motion, a request for a declaration that there was a failure of consideration in the deed. Now, we advanced, I counted them up, 9 different arguments in our response why the court should deny this motion. I heard Mr. Dennis briefly respond to one of the 9 today. They've not filed a reply with respect to the others. I'm going to go through the others quickly and address the one point he made in a little more detail. The first reason is they, who bear the burden here, have not conclusively established a failure of consideration. We've cited law that says the recital of consideration in an instrument of conveyance is prima facie evidence of its amount and the payment thereof, and the burden of proof is on the party who controverts it. We've cited law that says an acknowledgement on a deed is prima facie evidence that the grantor executed the deed for the consideration. Thus, it is their burden to establish the consideration existed and later failed. Given that this is a traditional motion for summary judgment, all inferences are to be indulged in favor of the non-movement, which is the defendants. We have a recital in the deed that this is for good and valuable consideration. That alone raises a fact issue precluding summary judgment. The second argument, even assuming that the only consideration for the transfer of Steen's interest was, quote, good and valuable consideration, which is referenced on the first page of the deed, which, by the way, is the assumption made in their motion. They've offered no summary judgment evidence as to what that good and valuable consideration was, much less than it then failed. They've simply said Steen didn't get any money, but they have not offered any summary judgment evidence that money was what was meant by good and valuable consideration, because the deed provides nothing in terms of any payment to Steen for transferring the interest. The third argument, and this is the one that actually Mr. Dennis didn't touch on. There is no competent evidence that what was meant by good and valuable consideration was a promise to pay, for which they then argue, well, he didn't get money, so somehow the consideration failed. They cite some piecemeal testimony from Margot, from which they attempt to infer that the consideration that's called good and valuable was to be 25% of the proceeds, but the testimony never says that. And even if it did, we've offered summary judgment evidence that establishes there was no such agreement. We've put that forward, which, if nothing else, raises a fact issue in dispute as to whether or not there was an agreement. So that should terminate a request for summary judgment. Next argument. The terms of the deed and the purchase and sale agreement, which we've included as part of summary judgment evidence, are contrary to their alleged oral agreement, thereby creating a fact issue. For instance, Section 4 of the deed provides, quote, this deed is expressly subject to the terms and conditions of the PSA, meaning the purchase and sale agreement, which terms are hereby incorporated into this deed by reference for all purposes. Well, Section 1.2 of the purchase and sale agreement, as amended, provides that the entire purchase price is to be paid to Margot's trust, not to any of the children. In fact, there's a disbursement sheet that would have a place for the kids to get money, but it shows nothing going to them. Thus, the purchase and sale agreement, which is incorporating the deed, raises a fact issue about whether they were to get any money. The next argument, even if they've met their initial burden, and somehow that burden shift to us, there is a material fact issue, whether there was a failure of consideration. The only language regarding consideration in the deed that the plaintiffs cite to you in the motion is the good and valuable consideration that's on the first page, that phrase, as if that were the only reference to consideration, but it is not. There are multiple other references to consideration in the deed. For example, the deed states in section 6 that as a material, and I emphasize the word material, part, and I emphasize the word part of the consideration for this deed, grantors and grantee agree that grantee, meaning Margot, is taking the subject assets as is, with any and all latent and patent defects, and there's no warranty by grantors, which included Steen, that the subject assets have a particular financial value or fit for a particular purpose. This portion of the deed constitutes a detriment to Margot and a benefit to Steen because consideration is a present exchange bargained in return for a promise. It consists either of, and this is according to the Texas Supreme Court, a benefit to the promisor or a detriment to the promisee. We've cited the Bryant v. Cady case that a promisee suffers a legal detriment when in return for a promise, the promisee surrenders a legal right that the promisee otherwise would have been entitled to expect. By agreeing to accept the property as is, Margot surrendered the right to assert the existence of any express or implied warranties or assurances regarding the property. So at a minimum, this is a benefit to Steen because he's able to transfer this interest, making no reps or warranties, and it protects Steen for potential future liability. They've offered no evidence or even argument that such benefit does not constitute legal consideration. But there's something else. The deed also states that it is in consideration of the transactions contemplated in the PSA, and then there's this key language, Your Honor, the receipt and sufficiency of which are acknowledged. That alone creates a fact issue because you've got a deed saying the consideration was received and it was sufficient. We cited the Bryant case, holding that a promise to enter into another agreement is legal consideration. They don't even attempt to respond to that. They're making an assumption that a benefit can only be the transfer of money. But we've cited, for example, the Anderson case that says the benefit does not refer necessarily to a money gain arising out of a transaction, but is reference to any advantage or benefit, slight but recognizable at law, derived. We cited the Buddy case out of Dallas. Sufficient consideration for the agreement may consist of a right, interest, profit, or a benefit, or alternatively, a forbearance. Also, Your Honor, Section 6.3 of the Purchase and Sale Agreement is entitled Indemnification by Buyer and provides indemnification to the sellers, which included Steen, for example, of any breach by buyer of buyer's reps or warranties. So if Blackstone, as buyer, breached a representation it made and later sued, the indemnification clause benefits Steen by protecting him from potential liability. They've offered no evidence or argument that's not sufficient legal consideration. And then finally, the deed states there is other good and valuable consideration. Now, Mr. Dennis says you can't use the parole evidence to contradict an unambiguous document. True, but you can use parole evidence, and we've cited the Lopez v. Rivera case and many others. The parole evidence rule does not bar evidence of a consistent collateral agreement, and parole evidence may be used to clarify or explain an agreement. We also went on to cite law that says courts may consider parole evidence to show want or failure of consideration or to establish the real consideration. That's from the Dallas Court of Appeals. We've cited law that says evidence that establishes what the, quote, other consideration was is admissible to establish the true consideration. We've offered summary judgment evidence that part of the consideration to Steen was that by transferring his interest, which, remember, according to the oil and gas interest, were worth nothing by the time Margot died to Steen, he received the benefit out of love and affection and for his peace of mind of helping his elderly mother monetize the value of her life estate so she would have immediate access to that money that she might otherwise never realize. We've also offered summary judgment evidence that Blackstone conferred a benefit of Steen because he wanted his mother to have the money the sale would generate, and the transfer of his interest was necessary to achieve that. This alone is sufficient consideration. As to this love and affection issue, While the consideration that we put forward is not based solely on his love of an affection, even if that were the only consideration, the courts have held that love and affection, especially in familial relationships, can be sufficient consideration to support a deed. Their only response is, well, those cases were parent to child, and you haven't cited child to parent. True, that happens to not have come up to the appellate court, but you've been given no argument, much less law, that says it wouldn't work the other way, much less a reason why it wouldn't work the other way. Now, the next argument we made, to which there's not been a response, even if there were an absence or a failure of consideration, that standing alone would not establish the deeds failed to convey title. We cited the Watson case that says mere lack of consideration would not have prevented deeds from conveying title. We also cited the Uriarte, Uriarte case that says ordinarily a mere want of consideration is not ground for the avoidance of an executed deed. In addition to lack of consideration, fraud or undue influence in obtaining the instrument must also appear. They have neither pled nor proven to you today there was fraud or undue influence. They actually had a fraud claim, but they dropped that in their latest petition, and they've not pled or proven undue influence. So for any of those 9 reasons, the second summary judgment should be denied, and for any of the 3 reasons, the first. Let me just briefly address the motion to strike. Whether or not you grant the motion to strike, for the reasons I've said, the motion itself should be denied. But to the extent they want to rely on testimony from Dan Britton, which they referenced, we have filed a motion to strike. You will notice when you were shown at least one of the excerpts, there was an objection made at the time, which of course was therefore preserved. And we believe those objections were proper. They cite pages 22, 159, and 160 of Mr. Britton's deposition. Questions regarding whether the deed was a gift or whether the children received anything. The answers are not admissible summary judgment evidence because they are seeking a legal conclusion as to whether this particular document, when you read it, provides a gift, and they are seeking for inadmissible parole evidence under their theory as to whether Dan Britton thought the kids got something or didn't get something. The same is true for Margot's deposition on page 172 when they ask her what Steen received. That, in terms of consideration, that calls for a legal conclusion. I objected. They didn't define for her what consideration meant and what they meant for her to then answer. And by the way, regardless, she said Steen received the benefit of helping her get the money, which we have shown itself alone can be consideration. So for all those reasons, Your Honor, we believe that both parts of the motion, understanding the third has been abandoned, should be denied. And I thank the court for its patience.
All right, thank you. Mr. Dennis, I'll allow you to respond briefly.
Yeah, yes, Your Honor, and I'll do briefly. Yeah, I didn't try to go over all 9 of their various arguments in my opening. I would just come back to the question is, what did Steen receive? I don't think they at least aren't directly challenging the case law that we provided, that it has to be good and valuable consideration. Once you've recited that, you don't get to go back to love and affection. They make that argument at the end that love and affection could be sufficient consideration, and they just haven't found a case since the 1800s that goes child to parent, but that doesn't mean you can't have it. We just never get there, because when you recite good and valuable consideration, it's not love and affection. It's the opposite. Otherwise, there'd be no point in a gift. So I would make that point. As to all these arguments about we're not making this argument, then there won't be any harm in the court finding it's not a gift. I mean, they keep saying that they're not making the argument, but that is literally the letter that Dan Britton sent to Jan and Eric saying that you've got nothing because your dad Steen relinquished or gifted away his remainder interests. And so they can't have it both ways. You can't have that as your principal reason for why you get to keep the money and then say, well, that's not really our argument. It doesn't make any sense. And we frankly didn't have the declaratory judgment in our original petition, but they made all these arguments in the depositions, and then we amended to add these declarations because they weren't asserting them as affirmative defenses, and so we have to deal with the deed. Now, he references an oral agreement, and that's not before the court because, frankly, the deed is separate what we say is, and there's several causes of action, but we say whether she was the fiduciary for the kids, and we think we'll be able to prove that she was their fiduciary, whether they all had agreement amongst each other, whether they were all in a joint venture to sell these interests together. Those are various causes of action that deal with how the parties agreed the interests should be divvied up. But what we focused in on is the deed itself that they are relying on fails on its own merit. So whether we ultimately go with fiduciary duty and we prevail that way, or whether whether we prove that there was an agreement amongst the three children and the mom about how they would distribute the proceeds, those will come up later. But the question is right now, the deed that they are relying upon for Margot, because he said in the opening, it's her money. She just decided not to give this gift. The only reason she got $15 million was because Steen and Ulrich and Kelly transferred these remainder interests. The summary judgment record includes evidence. She knows she couldn't have sold her life estate. Her life estate wasn't worth $15 million. She couldn't have sold it without the remainder interests. But because of this deed, she was able to sell it and get the $15 million, and now she claims it to be her money. But I just come back. So there's really no dispute that you have to have good and valuable consideration, and that the cases we cite about the parole evidence rule bars you trying to turn it into a gift after the fact. You can't undo the recitals in the deed. And then the second part of it is, did he receive any consideration? And they say the presumption, because of the recitals, is that there is consideration. I don't deny that. They say we hadn't met our burden to prove no consideration. Well, I offered the testimony of Dan Britton, the attorney for the transaction, saying Steen got nothing. Offered the testimony of his own client, who says Steen got nothing. And to deal with his motion to strike, if you look back at those excerpts, I don't ask about a legal term of consideration, as I read in the opening, and I won't waste time by redoing it. But I asked, did Steen receive anything? Just in open terms. What did he receive? The same to Margot, the same to Dan Britton. Did he get anything at all? And they both said, well, Dan said no, nothing. And Margot said he got the satisfaction of knowing I was taken care of, which again is not good and valuable consideration. That's the love and affection that would have to be in a gift. The only thing I heard, and I'll address this because I've addressed in the beginning, that they say would be a benefit. So us having proved via the uncontested testimony of Mrs. Burrell and Mr. Britton that Steen received nothing, the burden would be on them to show, no, he actually received something, or there is some fact issue about what he received. And all we hear are some legal arguments from Mr. Lowenson. And the only one I heard about what Steen got was this as-is clause. Okay, but he's got to prove how that's a benefit to Steen. He can't just cite random provisions and say they're agreements. Okay, what did Steen receive? How was the as-is clause a benefit? Now, it's like, if I deeded my house to Mr. Caldwell there, and the supposed consideration for the transaction was he took my house as is and wouldn't sue me if there were things wrong with the house. That's no benefit to me. I've still just gratuitously given him my whole house. Now, I think you could prove it. He doesn't have this, but you could have summary judgment evidence that my house was a waste site. And the benefit to me was not having to do a cleanup. I mean, there's certainly ways in which you could prove an as-is clause or these kind of clauses conferred a benefit on Steen. But us having proven through his own client's testimony, through the lead lawyer for this whole transaction's testimony that Steen got nothing, the burden would be on them to show some genuine issue of material fact as to him having actually got something. And all they point to is an as-is clause in the agreement, but no evidence of how that conferred a benefit on Steen. It's not a speculative, it might have conferred. He's got to have evidence that it did confer some benefit, some evidence that he can raise a genuine issue of material fact. He mentioned an indemnity clause, but again, there's no evidence in the record about how that indemnity clause would have possibly conferred a benefit on Steen. Steen had a remainder interest in royalties. There's no evidence, and he had no obligation to fund like an operating agreement. There were no liabilities associated with this. He either got money or he didn't, depending on the leases that drilled oil. And there's no evidence that he had any potential liability or losses or anything that would be remedied by an indemnity clause or essence clause. So in conclusion, our motion is simple. The deed itself recites good and valuable consideration. It can't be a gift. And part two, Steen didn't get any consideration. His client says it, the lawyer says it, and it would be their burden to raise some fact issue in response to that undisputed testimony, and they don't. All they do is just point to various provisions in the agreement, not tying them in with any competent testimony as to how that would benefit Steen. What did Steen get, and how was it a benefit to him? They can't answer that question, and therefore our motion should be granted on those 2 points. As to the effect of that, I agree, that's still up in the air. As to remedies, as to the effect of there being no consideration for this deed when there should have been, that will be for another day. But this will materially advance the case because this is their principal defense. Thank you, Your Honor.
May I make 2 brief points, Your Honor?
Yes, go ahead.
On the no justiciable controversy issue, Mr. Dennis says, well, look, there's no harm in giving us that. That's not the law. They bear a burden, and we've cited multiple cases showing that there is a controversy, and you don't get to declaratory judgment just because there's no harm in entering it. And by the way, there is a harm because they're asking for attorney's fees if they were to win that. As to the consideration, I'm not going to repeat everything I've said, most of which was not responded to, but in hearing Mr. Dennis, I think he is forgetting the fact that this is their motion, not ours. This is their traditional motion for summary judgment, which requires the court to indulge all inferences in favor of who? The non-movement, not Mr. Dennis. So we've cited you 4 different places in the deed where it recites consideration. That's enough to indulge all inferences in our favor. We don't have to affirmatively and conclusively prove to you anything. So as is a benefit. We cited law. Indemnity is a benefit. We've cited law. In consideration of closing a transaction as benefit, we've cited law. That's all our burden. We don't bear the burden. They do, and I don't think they've met it. Thank you, Your Honor.
All right, thank you. Let me ask you, gentlemen, their proposed orders that are on file with respect to the motion for summary judgment, as well as the motion to strike that counsel referenced to the court?
I believe there are, but as soon as we hang up, I'm going to make sure there are, and if there aren't, you'll have them within the hour.
Okay,
Yes, Your Honor. I'm pretty certain that there are, but I will double check as well.
okay. If you all will double check that, I am going to take a look closer at these cases that are cited, as well as that supplement that Mr. Dennis referenced in his argument. I am going to have a ruling for you gentlemen by tomorrow. The way that you will know that I ruled on this particular matter, I will sign whichever order I decide to enter, and I will email you a copy of the order that has been filed with the court.
We
So that is
appreciate it.
how you will know that I ruled.
We appreciate it, Your Honor, and I know I speak for all parties. Happy New Year, and congratulations on your new bench.
Oh, thank you so much. Thank you so much, gentlemen, and everybody stay safe, okay?
Thank you.
Thank you. Take care. Bye-bye.
Morning.
Morning, how are you?
Good. Hey, before the court gets on here, however you want to handle it, I re-looked at your motion, our contras. I'm not going to contest John Calra, so I'm going to let the court just handle that. I'll withdraw
Okay.
whatever we need to. Okay.
All
Morning,
right,
Mary.
good morning. Good morning. Going to go ahead and call this particular case at this time on the court's docket. This is cause number DC 20-01254, Catherine Rutland versus Allstate Fire and Casualty Insurance Company. I'm Judge Monica Purdy, new judge of the 95th Civil District Court. So I don't know that I've met everyone on this Zoom hearing, but I wanted to take a moment to introduce myself. I know this is the plaintiff's motion to strike defendant's counter affidavits, and I noticed that there's a response that has been filed there too. So let me have the parties at this time announce on the record their names and who they represent. I'll hear from the movement as it relates to their motion to strike, and then I'll allow a response.
Jason Holliday, attorney for plaintiff Catherine Rutland.
Thank you.
And Chad Kimball, Your Honor, I represent defendant Allstate Fire and Casualty.
All right, thank you. So Mr. Holliday, this is your motion?
Yes, Your Honor. Counsel just told me a moment ago that they are not going to be providing a response, or that we shouldn't need to discuss the issue of Dr. Carla. That they're conceding that affidavit should be struck. Counsel, just to make sure that I heard you correctly, is that right?
That's right, Your Honor. Not necessarily for the reasons set out in the motion, but I don't dispute that there's Dr. Calra's counter affidavit has some issues with it, and so we are not going to oppose plaintiff's motion for relief to have Dr. Calra's counter affidavit struck.
Okay, and to just be certain, that's the affidavit of Ricky R. Calra, is that correct?
That is.
Okay, just wanted to make sure.
So that should simplify things a bit, Your Honor. So just to kind of do a little bit of background, this is an auto accident case related to injuries Miss Rutland received on April 25th of 2017. We, in accordance with Section 18001 of the CPRC, we have provided proper affidavits relating to the reasonableness necessary of medical treatment and cost. And today we'll just be addressing the counter affidavit of Dr. or chiropractor Robert Canal. So there are three issues, well, I guess really four issues that we'll be addressing today. First is that Dr. Robert Canal has used the counter affidavit improperly to contest the causation element of Ms. Rutland's injuries. This is a violation of Section 18001F. I improperly cited to B, so I apologize to the court on that, but it is 18001F, which strictly prohibits using counter affidavits for the purpose of contesting causation. And then we'll also be addressing Robert Canal's qualifications as to his ability to determine reasonable cost of treatment provided by a diagnostic center, like for MRIs. And then there's some issues related to the reliability of his testimony, because it's based upon, first, it is based upon the workers' compensation reimbursement rates rather than the reasonable and customary cost, which is really comparing apples to oranges. And then the second issue is that it doesn't rely upon sufficient facts. So I'll address the first issue, Judge. As I previously indicated, Section 18001F of the CPRC prohibits use of a counter affidavit for the purpose of contradicting causation. Counter affidavits are simply supposed to be used to identify what treatment was reasonable and necessary, and not go into what treatment was caused by the accident, and then decide what was reasonable and necessary based upon that. Specifically, in the affidavit, the chiropractor identifies, and I'll just quote him, "There's no objective documentation within the file to suggest an injury on the basis of motor vehicle collision that issue beyond a soft tissue injury." And then he says there are no acute findings that are directly related to the motor vehicle collision in the MRIs. So essentially what he's saying is, look, of the injuries being identified, only soft tissue was caused by the accident, and therefore the only treatment that she should have gotten would have been about 6 to 8 weeks of chiropractic treatment. Again, that's a specific violation of the rule itself, and so therefore should be struck on that reason alone. The second thing is that I keep calling him doctor, I guess you can call him Dr. Robert Canal, also contests the cost of services provided by a diagnostic center. The case law is very specific on this. You know, the 1811 rule was created to reduce the amount of cost and time that would be needed at trial for a plaintiff to be able to prove up their case. And while the rule allows a custodian of records to provide these affidavits, it has a very heightened standard that it requires for counter affidavits, so that a defendant can't just come in, put some random facts on a counter affidavit and call it a day. It needs to be reliable and needs to be made by a person that's qualified. The Turner v. Peril case specifically identifies that the counter affiant must be qualified in the particular field that they're contesting. In that particular case, I think an orthopedic doctor was used to contest chiropractic treatment, MRIs, and some other issues. And the court said, look, just because he's a orthopedist, that in and of itself does not qualify him to testify on every type of treatment or the reasonable cost of that treatment. And one of the things that the orthopedist in that case testified to was to the reasonable cost of diagnostic services such as MRIs, CTs, things of that nature. So of course, if an orthopedist, based upon his experience or training experience, isn't qualified to testify on that, certainly a chiropractor wouldn't be qualified to testify regarding the reasonableness and the cost of treatment provided by a diagnostic center. The next thing would be that in discussing the reasonable cost of the chiropractic treatment, Canal doesn't use the standard of reasonable and customary. He looks at only the workers' comp reimbursement rates. Those rates are applicable only to workers' comp providers and to workers' comp type cases. No medical provider charges rates at the workers' comp level, and therefore he's not comparing apples to apples. It's not reliable to say that everyone should be charged the rate of the workers' comp reimbursement rates. He doesn't consider the fact that my client in this case was self-pay and did not use insurance. And for that reason, it's not reliable and shouldn't be considered and should be struck. The final thing is that he bases his opinion on insufficient facts, which further indicates that it's not reliable. Dr. Canal first just identifies, okay, since we're only dealing with soft tissue that was caused by the accident, and obviously he disregards all the other injuries that my client is suffering from, then under the disability guidelines, she should have recovered in 6 to 8 weeks. Therefore, only 6 to 8 weeks of treatment is necessary. What he doesn't do, however, is he doesn't consider the fact that my client, shortly after the accident, checked herself into a substance abuse facility for self-medication of alcohol. She realized that her pain and the stress of the accident was causing her to overindulge. And so she checked herself into a facility for 30 days. And then she had an additional week of all-day treatment. Thereafter that, the orthopedist recommended additional physical therapy while they awaited EMG studies. Dr. Canal doesn't consider any of this. He just says, well, look, if it's a soft tissue injury caused by the accident, then 6 to 8 weeks of recovery should be sufficient. He doesn't consider the fact that what happens when the patient doesn't recover in 6 to 8 weeks, when they're continuing to have ongoing pain, when their treatment has been delayed 30 plus days because of other necessary treatment and the like. And because he doesn't consider all the sufficient underlying facts, it deems his opinion unreliable. Those are the 4 issues that we have with Dr. Canal's affidavit.
All right, Mr. Kimball.
Thank you, Your Honor. Of the medical bills that are at issue in the case, in the totality of the case, we're really only dealing, I think, with 2 providers in Dr. Canal's counter affidavit, and that being a chiropractic facility and then the MRI facility where the chiropractor referred the patient out for that treatment. Very briefly, I guess with respect to the heightened standard, the greater burden of proof standard on counter affidavits versus billing affidavits, unquestionably it is a higher standard. It's not a records custodian. It's not somebody that works there that can simply fill them out. It's someone that has to base their opinions on their experience and skill and so forth. And so Dr. Canal, as his counter affidavit and as his attached to that CV indicates, he's been doing chiropractic treatment for cases like this, including some of the very same treatments that are at issue in this case for 30 years. So I do believe he is qualified. There's an issue about the causation. I guess I'll take them in order. The causation element. I don't know that a causation statement in an otherwise correct affidavit renders the affidavit fatal and defective. There's certainly no law attached by plaintiffs supporting that. If that was the law that says if you reference causation in a counter affidavit, then you lose the entire counter affidavit. I'd also say that I don't believe that I know it's not to be used for the purpose of making causation defenses, and I don't believe in any way that's what Dr. Canal did. He has one statement. He's given medical records regarding treatment from a motor vehicle accident, and in his counter affidavit, he has one statement in here. He doesn't say not injured from this accident. What he says is, based on all the information I've seen, after he summarizes it, there's no objective documentation within this file to suggest injury on the basis of the motor vehicle collision at issue is beyond that of a self-limiting soft tissue injury. So he is not trying to say that there's separate injuries over here that I'm not reviewing because I find those to be not caused by this. He's looking at everything that's been provided to him. He makes a statement that on the basis of the motor vehicle collision, I guess that's, certainly what's highlighted in the motion as the damning causation statement, but I don't believe he is separating or attempting to. And again, I don't believe if he does, or if the court finds that is a doctor separating what he believes to be causally related and not, I don't believe it renders this fatal. I understand the part that it will not suffice a causation defense. If we go to trial, we'll have to provide evidence of that later. The second argument, is that it's conclusory and fails to provide a reasonable notice. Again, I disagree. I think he does state his opinions. I understand that counsel may not agree with those, but it's not a conclusory statement. Candidly, one reason Dr. Kalra's counter affidavit's not being contested by us any longer is when you look at it, he says it shouldn't be this charge, it should be that charge. It's conclusory. Candidly, it is. I don't prepare counter affidavits by Dr. Calra or any of these others. So sometimes we come and it's not as developed as what we believe the courts are going to require, and we'll fall on our sword in those scenarios, as we've done here. The issue that he references, ODG guidelines, again, I heard it a minute ago that from counsel that, the case law is very clear. I don't know that the case law is very clear. Certainly there's no case law related to their motion that I'm aware of that says that a doctor who treats auto accident patients also treats workers' comp or work hardening, that he is prohibited from referencing as a source material or reference material his review or use or belief that ODG guidelines are applicable or not. ODG guidelines, in this case, he says he believes those to be a reasonable source, and relying upon those, as well as what his experience is in the practice, he believes this to be a 6 to 8 week treatment period, which would allow 10 treatments. And so he believes treatment beyond the 10 treatments. In this case, our plaintiff had 43 treatments, I believe, over 22 weeks or so. And so he finds treatments beyond the 10th treatment to be, certainly those passive modalities to be unnecessary. He doesn't have any issue with the referral to MRIs. In fact, he says the MRIs and the x-rays that were ordered are reasonable, even though he does believe that the MRIs, and he states it in his opinion, that the MRIs show nothing acute, and he's not making a causation. The concept or the issue when the chiropractor decided to that this treatment warranted more in-depth review through an MRI. Dr. Canal doesn't have any issues with that. What he does have issues with, and they're not significant, is his use of these maximum allowable reimbursement rates for the area where the treatment was, which was down in the Houston area. He lays it out. He couldn't be less conclusory, in that he goes through the entire mathematical formula and the conversion factors and so forth, and he lines up CPT codes per CPT codes, which is exactly the reason they have these CPT codes, so we can compare apples to apples, and goes through. And again, most of these are on the neighborhood of, they're not massive overcharges by the treating chiropractor. And again, he is Dr. Canal. He is a doctor of chiropractic. I'm quite certain that when the plaintiff's treating chiropractor, they're not going to not refer to him as a doctor. And so I do believe that he is, but some of these charges are where the treating chiropractor charged $43 for E-stim. Dr. Canal's opinion, based on the maximum allowable reimbursements, is that is $26. Most of these are in that neighborhood. I will say this, the great difference is when it comes to the two MRI facilities. And again, I guess the argument this morning is that, well, if he doesn't own an MRI facility, he can't testify as to what MRI charges are. I don't believe that's a correct statement of the law. Certainly there's no law that supports it. They relied upon the Turner versus Peril case that everybody is relying upon, which is just completely factually distinguishable from what we have here. The one thing about Turner versus Peril is it is an orthopedic doctor who is controverting every bit of that plaintiff's treatment, and none of that treatment was done by an orthopedic doctor. So he shoots holes in all of it and says, as an ortho, I don't think any of this other treatment is related, but none of it was within his area. A chiropractor has, for years, in the case of hundreds or thousands, in my experience, a chiropractor has referenced opinions on the necessity of referral to chiropractor or to imaging, and based on his experience and seeing the billing and so forth. And then in this case, even more with him relying upon the maximum allowable reimbursement rates, that he can comment and have opinions that support counter affidavits on the charges that are rendered by the imaging facilities who carry out the orders or referrals from the chiropractors, which is what was done here. And in this case, he finds that these MRI charges of essentially $3,500 per MRI are about tenfold what the maximum allowable rate is. Doesn't fuss at the necessity of it, just that the charges aren't supported. For these reasons, Dr. Canal, it's a 6-page affidavit that references all of the charges, the reasonableness of the charges, reference codes, where those come from. It is stated, it cannot be conclusory. Well, I say cannot be. It's one of the least conclusory ones I have, because all work is shown. I understand council disagrees with the work that was shown. I don't believe there's been case law provided in this court that, in this case, that suggests that his reference to these maximum allowable reimbursement rates are inappropriate, other than in plaintiff's motion. For these reasons, again, notwithstanding Colera's, what we understand will be the strike of his counter affidavit, we believe Dr. Canal does meet this burden provided by Chapter 18 in counter affidavits, and so we'd ask that the motion be denied.
All right, thank you. Mr. Holliday, I'll give you some brief final words.
Sure, Your Honor. First of all, we'll address those issues again in order. The causation element, Rule 18001F says you cannot use an affidavit to dispute causation. And the reason for that is for what I'm about to state, is because the entire basis of the amount of treatment that Dr. Canal suggests is needed is based on the fact that the other treatment was not caused by the accident. He does specifically say, he says, this is a quote from his affidavit, "There are no acute findings, and the findings are not directly related to the motor vehicle collision at issue." So he's saying that anything other than soft tissue, it was not caused by the accident. That's a violation of the rule. And then the entirety of his opinion as to what treatment was needed is based, it only discusses the soft tissue. So it doesn't contradict the other treatment that, an affidavit should say, look, here's the condition of the person. Based on the condition, we don't care about what caused it. Here's the condition and what treatment is needed. He doesn't do that. He's saying, here's the condition. Of that condition, only this part was caused by the accident, and therefore only this part is this type of treatment is needed to treat that part that is caused by the accident. And that's the whole reason why you can't put causation arguments in the affidavits, because it defeats the purpose. The second issue is on the imaging cost. Counsel discusses his qualification to be able to identify if a MRI is needed. Well, that's not being contested here. He says the MRI was needed. He's contesting the cost. And a chiropractor, because of what they do, they should have no reason to be looking at the bills to an MRI facility or reviewing them. And his exposure to it doesn't qualify him for that any more than mine does. I probably look at as many MRI bills or more than the chiropractor would ever see, because he's not looking at bills, he's looking at records. So he's not qualified to identify what's reasonable in terms of cost from an MRI facility. And the Peril case, it's the standard because it's talking about your qualifications must be in that particular field. An orthopedist can't testify as to what chiropractic treatment is needed. An orthopedist can't testify as to the reasonable cost of MRI facilities. And just like an orthopedist can't do that, a chiropractor can't do that. And then with regard to the reliability factors, if the standard is reasonable and customary, he's looking, and the basis of his opinion is entirely based upon the workers' comp reimbursement rates. The workers' comp reimbursement rates are not reasonable and customary. They are rates set statewide at a particularly low level, and there is no facility in the state that would charge those rates. So that's not reasonable and customary. It's the wrong standard and not reliable. And then the final issue, we're not contesting his expertise as a chiropractor to identify what chiropractic treatment is needed. It's just that his opinion has to be based upon the condition of the patient, not based upon the conditions he believes were caused by the auto accident. Those are two separate standards. And the way that the rules are set up are identified, so you don't discuss causation. And we're not saying that causation, just because he says the word not caused, that the entire affidavit is inadmissible or should be struck. It's because he bases his opinion on only those ones that were caused. And so that is the reason why it should be struck, because it puts it outside of what the intended use of these counter affidavits are for.
All right. I know that I am looking in the court's file. I wanted to just make sure that there are orders uploaded with respect to the hearing and the affidavits that issue. Do you know if you all have hearings on file? I mean, not hearings on file, I'm sorry, orders on file. I'm looking at a notice of hearing and said that. Do you all know if you have orders uploaded?
Plaintiff does, and I believe that I've seen that the defendant has done so as well, Your Honor.
Your Honor, I will say this, though, the one that we would have submitted when we filed our response would have been that plaintiff's motion as to CALRA be denied. That's not our position, as we've made clear to the court. So if you want me to submit one that does address the outcome of CALRA's being granted and then our proposed denial of canals, I can have that done this morning.
Yes, if you could do that this morning, make sure Mr. Holliday gets a copy of your order. But if you could submit that, I'm going to have a ruling for you gentlemen by the end of today. The way that you will know that I ruled is I will sign whichever order I do enter, and I will push a copy out to you of my signed order via email.
Thank you,
Very
Ron.
well.
All right, then that concludes our hearing. Do you need anything else, Mr. Kimball?
I just wanted to welcome you to the bench, Your Honor. So,
Oh,
yeah,
thank
I
you.
look
Thank
forward
you.
to
I
it.
appreciate it. Okay,
Very
I'll
good.
look forward to receiving the order. Take care.
Thank you.
Bye-bye.
James, you're sideways.
Sorry about that.
There you go.
Better?
How you doing?
I'm good. How are you?
Good.
I'll get it. I got to use my phone because I'm at the office and my desktop doesn't have a microphone. So
Yeah, mine doesn't either. So I use my phone all the time. It actually works out better. Sometimes I get stuck in a car. It's like, okay.
yeah, you can walk around. Yeah, it's actually easier sometimes.
Yeah. I think we're waiting on Virginia. She just sent me the passcode. I said, I already had it. I was like, okay.
I'm here.
Hey, there you are.
Yeah, I sent you the link, but I didn't send the passcode. So I wanted to make sure
Yeah.
Clara had the passcode.
Yeah. No, I actually, when I scrolled down on the email you sent, it was already on there. It was attached toward the bottom, but I sent it to her because they had texted me and said, we need a passcode. And I said, okay.
Perfect.
Did you get your thing done yesterday? Are y'all still in it? Virginia?
We're still in it.
Oh, boy.
Good morning.
Good morning, Your Honor.
Morning, Your Honor.
Good morning. All right, you all are set this morning for approve up. Let me go ahead and call the case because I know our court reporter is on this Zoom hearing. The case is cause number DC 20-00982, Clara Bradley versus Walmart Stores Texas LLC. Do we have everyone on the Zoom hearing that we need in order to go forward with the prove up?
Yes, we do, Your Honor.
Yes, Your Honor.
Okay, all right. Let's go ahead at this time and get on the record everybody's name and who they represent. I'm Judge Monica Purdy. I know some of the people on this Zoom hearing, but not all. The new presiding judge of the 95th District Court. So I wanted to just take a moment to introduce myself to you. And let's go ahead and have announcements on the record at this time.
James Bogus here on behalf of the plaintiff, Your Honor.
Thank you.
Virginia Cox on behalf of Walmart Stores Texas LLC.
All right, thank you, Mrs. Cox.
Esteban Gonzalez, guardian ad litem appointment for the minor DH.
All right, Mr. Gonzalez, good to see you.
Good to see you as well, Your Honor.
All
Welcome.
right. Thank you. Anybody else? All right, let me ask this. Has there been a proposed judgment that has been submitted to the court?
There has, Your Honor. I submitted it earlier this morning, so it was a little bit late. I'm happy to forward it to a different email. I believe I forwarded it to Deanna early this morning.
Okay. Do you know if it has been, well, if you forward it there, I'm here at the courthouse, so I'll be able to get it. I just wanted to make sure that we had it.
Yes.
All right. Are we going to be having any testimony today taken?
Your Honor, Miss Bodley and the minor child should be either on or trying to get on. We sent them the passcode a few minutes ago. So I'm hoping they are there. If they're not, I can text them and see where they are.
Okay. Only other person that I see, let me look at the participants that I have. Hold on a moment.
They'll be on one phone. It should be under Clara Bodley or Deanna.
Deanna Harris is on.
That's her. That's the minor
Okay.
child.
Okay. All righty. Okay. So it looks like they're on mute for right now. Mrs. Harris, can you hear us? Or is that Mr. Harris, Deani? I don't know if that's
No,
male or
it's
female.
Miss. It's Miss. Is Miss.
Miss. Okay,
the minor
Mrs.
child.
Harris. Mrs. Harris, are you able to hear us? I believe she's trying to move towards the computer. I see them trying to assist her.
And Your Honor, DH is Miss Harris. She's the minor. Miss Bodley is the legal guardian.
Okay. All right. Mrs. Harris, are you all able to hear us over there? I can see you, but I have not heard you all. Can you hear us? I need you to speak back to me if you can hear me. I don't think they're able to hear us, Mr. Gonzalez.
Okay. I don't know if they have a microphone on. Are they? Let me see if I.
Oh, no, wait a minute. Is that Mr. Okay. Can
Miss
you
Barbara?
hear now? Mrs. Harris, can you hear us?
All right, hello?
Yes.
There we are.
There we go. Okay, able to hear us now. Thank you. All right, you
Sorry
can hear
about
us
that.
fine. Is that correct?
Yes, ma'am.
Okay, no problem. No problem. All right, I'm Judge Monica Purdy. I'm going to be presiding over the hearing this morning. All of the lawyers that are on this particular Zoom conference, they have announced. So I'm going to hear from the plaintiff at this particular time with respect to the prove up. So counsel for the plaintiff, I'll go ahead and let you proceed. If you are going to be questioning any witnesses, I'll swear them in before you begin to ask any questions of them.
Okay, thank you, Your Honor. I'd be happy to do whatever the court would like. If you'd like me to question Ms. Bodley, who is the guardian and next friend of the minor DH, or if Mr. Gonzalez would prefer, I'm fine with that as well. But
Okay.
Go ahead, James. You can take it. I've already explained her.
Okay.
You'll probably be asking the questions.
okay, then I'll just go ahead and briefly I'll call Clara Bodley.
All right, Mrs. Bodley. Mrs. Bodley, if I can get you to raise your hand for me right there. Do you solemnly swear and affirm that the testimony you're about to give will be true and correct to the best of your belief and knowledge? If so, say I do.
I do.
Okay, thank you. Counsel, you can go ahead and proceed and ask some questions of Mrs. Bodley at this time.
Thank you, Your Honor. Good morning, Ms. Bodley. It's James Bogus, the attorney for you and for your granddaughter, Deani. Do you recall? Do you remember me and
Yes.
understand who I am? Okay. We represent my law firm, and I represent you and your granddaughter on in connection with a lawsuit that was filed against Walmart. Is that right?
That's right.
Okay. And the basis of the lawsuit was Deani alleged that she slipped and fell and injured herself at a Walmart store. Is that right?
That's right.
Okay. And you gave a deposition in this case back in July. Do you remember that?
Yes.
Okay. And then sometime after that, we discussed and came to a settlement agreement on the case. Is that
Yes.
right?
That's
Okay.
right.
And did you understand at that time that it was your decision whether we accepted the settlement that was offered or proceeded along toward a jury trial?
Yes.
Okay. And the offer, which was the top offer that was made by Walmart, was a total of $27,500. Do you recall that?
No, I don't.
Okay. Okay. And ultimately, you agreed to an amount, of course, after the bills, you knew that the bills would be taken care of. Is that right?
Right.
Okay. And you agreed to an amount for Deani in addition to the bills being paid. Is that right?
That's right.
Okay. And I believe the amount at the time, we weren't sure how much, I couldn't tell you exactly how much it would be because it depended on some reductions that I was negotiating at the time with the medical providers. Do you recall that?
Yes.
Okay. And I was conservative in my estimate with you and told you I thought I could get $3,000 to go to Deani back at the time we were settling on top of the bills being paid. Do you recall that?
I'm not quite sure.
Okay. Okay. Well, you understand,
Yeah.
I did negotiate reductions on the medical bills. And
Right.
we've also reduced our fees. And at this time, out of the $27,500, $9,237.68 is going toward the medical bills. And $8,007.01 are going to Deani, which I believe will be going into the registry of the court until her 18th birthday. Is that your understanding? Okay.
Yes, I do.
And as you sit here today, do you believe that it was in the best interest of Deani to accept that deal and accept that offer?
Yes.
Okay. And she will turn 18 sometime this year. Is that right?
That's correct.
Okay. And you're okay with the money going into the registry of the court until her 18th birthday?
Yes.
And it will gain, it should gain a little bit of interest during that time that it's in the registry. Okay.
Okay.
Let's see. I believe that's all I have right now. I might have missed some questions. Some of the other attorneys might have questions for you. I'll pass the witness.
All
Okay.
right. Thank you. Mrs. Cox, do you have any questions for this witness?
I do, Your Honor. Ms. Bodley, my name is Virginia Cox. We met previously. I represent Walmart Stores Texas LLC. Do you understand who I am and who I represent?
Yes.
Are you the grandmother of the minor in this matter?
Yes, I am.
And are you the legal guardian of the minor
Yes.
in this matter?
Yes, I am.
Do you understand that we're here today to ask the court to dismiss the claims that you have brought against Walmart Stores Texas LLC on behalf of Deani?
Yes.
Do you understand that you have no obligation to dismiss this case at this time and you have the right to proceed further and try this case to a jury?
That means you can push forward and see.
Would you like me to repeat the question?
Yeah, I'm kind of explain a little bit.
Yeah. Do you understand that you have no obligation to dismiss this case?
It means you don't have to close it. You can continue on.
Yes.
And you understand that if you decide not to dismiss this case today, that you have the right to proceed further and try this case to a jury? Do you understand?
Yes, I do.
Let her finish.
Do you agree to waive your right to a trial by jury or the court?
I don't want no jury.
So that means you're done with the case.
I'm done with the case.
Just say, don't, oh God. Just say yes.
I'm
Just say
confused. I
yes.
mean,
Just say
yes.
Mrs. Botley and Mrs. Harris, Deani, we have a court reporter on this particular Zoom hearing. You can't see her on camera, but she has to take down every word that is being said in order for us to have a complete record. So be careful talking over each other or answering the question before Mrs. Cox finishes, because she has to take down that, and it's very hard to do when people are talking. So just wait until that's answered. And it's perfectly fine if Mrs. Botley doesn't understand a particular question for Mrs. Cox to try to explain that to her. Or Deani, if you want to assist explaining to your grandmother, just make sure that you speak up. Only speak at one time so that the court reporter can take it down, okay?
Okay.
Yes, ma'am.
All right, so Mrs. Cox, I'm gonna ask you to ask your question again about whether or not Mrs. Botley understands that she has the right to waive a jury trial.
Sorry.
That's okay.
Bodley, do you understand that you have no obligation to dismiss this case?
I'm confused. Does that mean I don't want to, I just want to settle the case and be done?
What she's asking you, Mrs. Botley, is whether or not you understand that you do not have to dismiss the case. The case does not have to go away. Do you understand that you have the right to still prosecute this case? You have a right to still have this case going? That's just, and then she's going to have another question for you. Do you understand that? You don't have to settle this case. It can continue, but you are choosing to settle. But she just wants the answer to that particular question. Do you understand that you don't have to settle this case?
So do you want to continue going or if you want to stop and let it settle. Settle means accepting what they're giving you.
I want to sell them.
All right. Thank you, Deani, for clarifying what me and Mrs. Cox were not able to. We appreciate that. Go ahead, Mrs. Cox.
Thank you. Now, in light of the settlement, do you agree to waive your right to a trial by jury and by the court?
That means, are you agreeing to accept what they're saying? Like,
Yes.
you're done with it?
Yeah, I'm done with it. Yes.
Do you agree and do you understand that when Deani turns 18, she will not have the right to sue for any money based upon this incident that was the basis of this lawsuit?
Can you repeat that? You're cutting out.
Oh, I apologize. Yes. Ms. Bodley, do you understand that when Deani turns 18 years old, she will not later be able to bring a lawsuit pursuing these claims against Walmart for this incident?
Yes.
And have you and Deani spoke with the guardian ad litem in this matter? Steve Gonzalez?
Yes.
And have you made the decision to dismiss this case based on your own free will and based on the recommendations of the guardian ad litem?
Yes.
Do you believe the settlement is in the best interest of Deani?
Yes.
Do you wish to ask the judge to approve the dismissal and the agreed final judgment?
Yes.
I'll pass the witness.
All right, Mr. Gonzalez, any questions of this witness?
Just briefly, Your Honor. Miss Bodley, you and I had a chance to speak regarding this whole matter over the phone a couple of times. Is that correct?
That's correct.
And just to make sure, you and I spoke about the amount of the money that would be coming to your granddaughter, and that money was to be her money when she turns 18 years of age. Is that correct?
That's correct.
And you understood that by settling this matter today, that you and your granddaughter, when she turns 18, are releasing Walmart completely of any other claims of damages against them.
Yes.
Okay. You do understand that if anything happens to Deani between now and her 18th birthday, that medically, that would be anything related to this accident, that you would still have the responsibility of getting her treated on your own. Is that correct?
That's correct.
Okay. And how is Deani today? Is she back to being normal as a senior in high school?
Yes.
Okay. Pass witness, Your Honor.
All right. Counsel for the plaintiff, any additional questions of this witness?
No, Your Honor.
All right, Mrs. Cox, any additional questions?
No additional questions. We asked the court to approve the settlement.
Okay, all right. And let me ask counsel for the plaintiff and the defendant, has there been a agreed upon fee for the guardian ad litem, and is that included in the proposed judgment that the court is going to review?
Your Honor, there has been an agreed fee for the guardian ad litem. I believe Mr. Gonzalez submitted an order for the court, and I've attached that and sent that earlier this morning to Ms. Ruse. I apologize if I'm saying that.
Yes, no, Mrs. Ruse. Okay, all
yeah,
right.
I sent it all in one email.
Okay, and Mr. Gonzalez, have you filed your report as the guardian ad litem in this particular case?
Yes, ma'am. I filed my report, and I also filed a separate order of approving fees and discharge of my guardian appointment. And have had that filed with the court. It should be available.
Okay. One other question, I'm just trying to think through, since we're all on a video conference, the settlement agreement, does it have the appropriate signatures? And has that also been submitted to me, or is there something I need to sign on that?
We have not submitted the settlement agreement.
Okay.
To protect confidentiality.
Okay.
But it has been circulated through the parties, and it is consistent with the numbers laid out in the judgment that we have forwarded to you by email.
Okay, all right. I am just trying to, normally when I have a prove-up that has a settlement agreement, they have that here in court, and I know they have to get the signatures. Just wanted to make sure that we have that there. Okay, the court will review the proposed judgment that has been submitted, as well as the order approving the fee of the ad litem, as well as the ad litem report. I will have that signed for you all by the close of business today. You can simply check the court's e-filing system. It should either be available for you to view today or first thing in the morning. I'm not sure when the clerk will get it up. So that will be the order of this court to grant the proposed judgment. Just wanted to take a moment to speak to Mrs. Diani. Mrs. Diani, can you come closer to the camera so I can see you? All right.
Hello.
Hello there. So you're a senior in high school?
Yes, ma'am.
Okay, where do you attend high school?
Lake Collins High School.
Okay, good, good. Well, I just wanted to tell you that lawyers explain legal terms to lay people like your grandmother. So getting your grandmother to understand what we are asking, and I tried to explain it, Ms. Cox tried to explain it, but you did a better job in explaining that to your grandmother. And I wanted to point out to you that that's a gift. That's a gift that you should pursue, okay? I know that I am the only one in my family that was the lawyer, and a lot of people look to me to explain things to them, but when you can explain legal terms to lay people, you should pursue that. So I'm hoping when these funds are available to you, when you turn 18 later this year, that you might decide if there is another class that you can take after high school to pursue that, because I think that is something that is needed. So I just want to take a moment to tell you that, Mrs. Diani, okay?
Okay, thank you.
All right, well, good luck to you. I'm glad that you are doing well. I want you to continue to do well, and I'm very serious when I tell you that that is a gift that everybody cannot do and everybody is not able to do. All right. Okay, Mrs. Botley, good luck to you all. That concludes our hearing. Again, I'm going to sign the proposed judgment that has been submitted to the court. It should be on file by the close of business today or first thing in the morning. Is there anything further from the plaintiff's counsel, defense counsel, or guardian ad litem?
No, Your
I
Honor.
have a question.
Yes.
So I kind of miss school to be here. Is there like a something y'all could send to the school so they don't count that towards like my absences?
Sure. Mr. Gonzalez, is there something, I guess, that I can send to you to get to Mrs. Diani to let them know that she was actually in court this morning, even though it was virtual?
Yes, Your Honor, if you want to go ahead and send me, I know you guys usually issue some type of note or letter, send it to me and I'll get it forwarded over to Diani and have it sent directly to the school if necessary.
Okay, all right. So Mrs. Harris, I'm going to go ahead and get that over to the guardian ad litem, Mr. Gonzalez, so that he can get it to your school so that they know where you were today, even though we are virtual, okay?
Okay, thank you.
All right, that concludes our hearing. Thank you very much. Take care.
Yeah.
Bye-bye.
Bye.